Criminal immunity for a former president enjoys no support from Fitzgerald's recognition of civil immunity, Fitzgerald being a precedent. In Fitzgerald, this court held that a former president is immune from civil damages suit based on official acts within the outer perimeters of presidential responsibility. The court explained that a private person's interest in recovering damages was outweighed by the burden on the presidency posed by the threat of scores of civil suits brought by people affected by presidential decisions. The court thus held that immunity from civil liability under otherwise valid laws is a functionally mandated incident of the president's unique office, rooted in the constitutional tradition of separation of powers. In other words, court deemed such immunity to be required by Article 2 because private damages suits would prevent the president from accomplishing his assigned functions. Applying Fitzgerald reasonings in this context, however, leads to the opposite result. Article 2 does not grant a former president absolute criminal immunity because the calculus on each side of the scales fundamentally differs. The interest in enforcement of federal criminal laws is far weightier than the private damages claim at issue in Fitzgerald. So differentiating between the civil case and the criminal case. And Jack Smith goes quite extensively into how civil cases are different and the standard of criminal cases is far more rigorous. The interest in applying federal criminal law to all persons is compelling. The charges in this case, alleging a president's crimes to overturn an election and perpetuate himself in power, illustrate the compelling public interest in enforcing the criminal law. The commitment to the rule of law is nowhere more profoundly manifest than in criminal justice. Indeed, the primary constitutional duty of the judicial branch is to do justice in criminal prosecutions. That's according to Nixon. Accordingly, Fitzgerald emphasized that there is a lesser public interest in actions for civil damages than in criminal prosecutions. And although the court declined to approve the exercise of jurisdiction over the president in a case involved in a merely private suit for damages, it acknowledged that the exercise of jurisdiction over the president has been held warranted in order to vindicate the public interest in an ongoing criminal prosecution. This case involves a countervailing Article 2 consideration absent in Fitzgerald. Petitioner's immunity claim would frustrate the executive branch's enforcement of the criminal law. A federal prosecution, in contrast, implicates the president's constitutional responsibility to take care that the laws be faithfully executed. The Attorney General and federal prosecutors help fulfill that constitutional function. Allowing a former president to assert absolute immunity from applicable criminal laws would frustrate the executive's constitutional authority and responsibility to enforce those laws. So essentially saying that it is the president's job to enforce the laws, not break them. It would be a striking paradox if the president, who alone is vested with constitutional duty to take care that the laws be faithfully executed, were the sole officer capable of defying those laws with impunity. Defies logic. The interests on the other side of the scales also weigh against criminal immunity because the possibility of federal criminal prosecution after a president leaves office imposes a much lesser burden on the executive branch than private civil suits at issue in Fitzgerald. Those concerns do not translate to the federal criminal context. All federal prosecutions must originate in the executive branch itself, acting through the DOJ. Institutional standards of impartial prosecution are embedded in long-standing DOJ norms set forth in department policy. Then the grand jury provides a further independent check against abusive prosecutions. Finally, Article 3 courts, including this court, ensure that any prosecution of a former president stays within constitutional limits. The executive branch and the criminal justice system contain strong safeguards against groundless prosecutions. Federal prosecutors are required to make prosecution decisions based on facts and the law, and they may not consider a potential defendant's political association activities or beliefs. This court has explained that based on long experience, absent clear evidence to the contrary, courts presume that federal prosecutors have properly discharged their official duties. Federal felony indictments must be returned by the grand jury. The Fifth Amendment, which is a constitutional fixture in its own right and serves as kind of a buffer or referee between the government and its people. Grand juries are prohibited from engaging in arbitrary fishing expeditions and initiating investigations out of malice or an intent to harass. So here, Jack Smith is really hammering it home, I believe, because Donald Trump, in the court of public opinion, has been saying that there is some sort of a political motive and malice on the DOJ's part for bringing these lawsuits. But what is clear here is that there is actually judicial backing for, and there are checks built into our system with the grand jury and with the Fifth Amendment to ensure that defendants are given all of their rights. Prosecutions are also subject to public scrutiny and rigorous protections for a defendant's rights. The accused is guaranteed a fair trial with an array of procedural rights. The Sixth Amendment, that's the Constitution's Sixth Amendment, and the government bears a burden to prove its allegations beyond a reasonable doubt to a unanimous jury, which guards against abusive, unfounded prosecutions. These established safeguards sharply contrast with the potential barrage of unscreened private damages actions that concerned the Fitzgerald Court. Article 3 courts, including this court, provide the ultimate check against politically abusive prosecutions of former presidents. Politically motivated prosecutions violate the Constitution, and courts will review a former president's claims meticulously. The groundless threats of politically motivated prosecution that petitioner fears would not survive such review. Courts will also enforce a due process principle that a criminal statute must provide a person of ordinary intelligence fair notice of what is prohibited. Here, the district court correctly rejected petitioner's due process challenge to the charged statutes, but those requirements would protect a former POTUS if a case arose in which he lacked fair notice. This is a procedural point of getting notice of your actions. Together, these layers of familiar standards refute petitioner's contention that without his novel absolute immunity claim, the president cannot function and the presidency itself cannot retain its vital independence.